that prosecutor and I have stipulated that you could hear this motion. And also for the record, I just wanted to say that my son is videotaping these proceedings.
Well, let him come up here right next to you.
Actually, Your Honor, he's fine right there. He can
No,
hear.
I'm gonna tell you, I want him up here if he wants to video.
Okay. Bring it up.
And then, as Mr. Cooley said, we're both fine with you hearing it, if you're fine with hearing it. I wasn't sure who was going to be on the bill today, and put it on the calendar.
Well, I'm on it.
Who would you like to be?
Right here.
All right, let's see, Mr. Cooley, it's your motion, if both sides are ready.
Thank you, Your Honor. Your Honor, I bring this motion for a new trial on 3 grounds that I've listed and one other ground that I have not listed, but I will elaborate on that one. The first ground, defendant at no time, oh, by the way, Your Honor, I do have a copy here for Your Honor.
I'll give that to the deputy, I'll let him do that. Thank you, Mr. Cooley.
Number 1, defendant at no time entered a formal plea at any proceeding, nor did any trial court enter a formal plea on the defendant's behalf. And number 3 relates to, ground 3 relates to ground 1. The jury was never informed that the defendant had entered a plea. When the trial court read the jury instructions to the jury, the trial court omitted from the jury instructions this sentence: the defendant has entered a plea of not guilty to this accusation. And the trial court also left out just below that where it says neither the accusation, he read that, but he left out nor the plea of not guilty should be considered as evidence. If a plea is not entered and the jury is not informed that the defendant has entered a plea, I was confused as why the trial even took place. Unless the jury is informed that the defendant has entered a plea of not guilty, I'm not sure that they're even allowed to hear the case. On those 2 grounds, I'm asking for a new trial. And on ground 2, the defendant received incomplete jury questionnaires. Now, at the time, during voir dire, when the prospective jurors were brought into the courtroom, I was handed a stack of jury questionnaires, and these are them. There's 101 questionnaires there, and there were only 18 prospective jurors in the courtroom. And the defendant, I didn't have enough time to even try and pull out the questionnaires for the prospective jurors that were in the courtroom. Furthermore, Your Honor, as I had a chance to go through them at home, there were 2 juror questionnaires that were missing. And both of those were jurors who were prospective jurors in the courtroom at the time. I wasn't made aware of this until after the trial. So for that reason, I believe that I am entitled to a new trial.
Mr. Bennett?
Judge, the state's response would be that and I'll just address these in order that he has enumerated them. Number 1, that he never entered a formal plea. Your Honor, he refused to state on the record whether or not he pled guilty or not guilty. I don't recall which judge was on the bench that day at his arraignment, but I believe the judge entered a guilty plea or a not guilty plea for him, as is the standard procedure in a situation like that. As far as the jury questionnaires are concerned, under enumeration 2, Judge, as you know, not all jurors fill out their questionnaires, or at least not all jurors return them to the clerk of court. The state, frankly, doesn't really have any other knowledge or statement about that. I would assume that we didn't receive the same questionnaires that he didn't receive. And then third, as far as the jury never being informed that the defendant had entered a plea, there was a jury instruction about a not guilty plea. Mr. Cooley requested that Judge Adamson not instruct them regarding that because he maintained that he had never entered a plea at trial, and that's why the judge didn't read that instruction to the jury. And it was on his own request that the judge did that.
And if I may just add something, at my arraignment was presided over by Judge Motes. And at the time of my arraignment, I was arguing jurisdiction over the case. And I encourage the court to view the transcripts of the arraignment, and it will show that the trial court nor I never entered a formal plea.
All right, I think this, did the state conclude its argument opposing the motion?
Yes, Your Honor, we have one other matter to address, but it has nothing to do with this motion.
Well, with regard to this motion then, anything else? Mr. Cooley, you get the last word, it's your motion.
Yes, Your Honor. Prior to, or I should say on the date of the trial, October 21st, prior to the trial starting, I informed the trial court that I had been at the emergency room that early morning before, that night before, that early morning before, and that I was given prescription medication, and one of the medications was hydrocodone, and I was hoping the court would have continued the case based on that, because I believe that that medication may have caused me to make some errors in judgment during the trial, and I would also like the court to take that into consideration for granting a new trial.
Did you move the court for a continuance?
I did, Your Honor.
And the state's response to that would be, I do recall him stating that he had been at the emergency room the night before. I don't believe anything further was said about that. He did move for a continuance on several different grounds. None of them were based on him being under the influence of any medication or anything like that, Your Honor. But the state really, nothing else was said about hydrocodone or anything like that day.
All right, again, last word, Mr. Cooley, anything else you want?
I'm good. I'm good, Your Honor.
Okay, all right, the court will take under advisement and carefully consider the motion for a new trial, and will turn out an opinion or a ruling, and make sure a copy goes to both sides.
Okay, there is just one other thing, and it's not related to this motion for a new trial. Prior to the trial, I still had that motion to dismiss for failure to properly arraign, and the court said that it was Your Honor who made a ruling on it, so we didn't hear the motion. He said Your Honor had made a ruling on it, but the defendant was not aware of any ruling. There was nothing done in open court. There was nothing sent to the defendant as far as any decision you had made on that motion. So I was confused about that, Your Honor.
And Judge, if I recall correctly, I believe that he did make that motion, and it was based on one that you had heard. Judge Adamson read something that he said he thought had been written. He read something in your file into the record that he said was your thoughts on the case. I don't recall exactly what it was, but he basically ruled on Mr. Cooley's motion based on a record that you, or notes that you had written.
And the motion was to do failure to properly arraign Mr. Cooley?
Yes, Your Honor. You had, at the motions hearing, you had continued, you had reserved your decision on that motion because Your Honor wanted us to submit some case law, at which time the defendant did. I don't know if the prosecution ever did, but then when that motion was to be heard, another judge was presiding over that day, and he had continued the case so that you could hear this motion, and then when it came to trial, you had never heard the motion. You had never heard the continued motion with the case law. And he, the court read, I'm guessing there were some notes that you had written down. I have no idea what they were. He was just reading some things that you had wrote down and denied my motion based on what you had written. So I was, totally confused by that.
Well, if I did not formally and accurately in writing deny the motion, then I hereby deny the motion. In as much as I think that was Judge Adamson, the trial judge's rule as well, and then he proceeded with the trial, which took place, a couple of weeks ago, is that right?
Yes, Your Honor, I believe it was.
I think that probably takes care of the record in that.